everyone, it's me, Lauren Cadillac with Cadilac Law. Welcome today. Before we get into the good stuff, just so you know, nothing you hear today creates an attorney-client relationship. None of this is legal advice. I'm just giving you knowledge, telling you what I know. It's up to you what you do with it, but in no way, shape, or form am I giving you legal advice or creating an attorney-client relationship between you or myself or my firm, Cadillac Law. Today, we are going to talk about power of attorney and what they can and cannot do. This is such an important topic, y'all, and I get people calling all the time who are a power of attorney that have done something that is legally incorrect. So I want to try to help alleviate that. Before we get talking about that though, make sure you push the button wherever it may be, hit like or subscribe, let the algorithms know I'm doing my job. Okay, so in Texas there are two types of power of attorney. Sorry, I stopped because I just had surgery on this hand, so I can't. Two types of power of attorney. One, medical. That one's pretty self-explanatory. When you're a medical power of attorney, you're going to make medical decisions for the person you're power of attorney of. That only is necessary when that person cannot make medical decisions for themselves. So, for instance, when I was in a 4-day coma, someone else had to make medical decisions for me. That's what the medical power of attorney would have done. Then there is statutory durable power of attorney. This is kind of what I call like your business power of attorney, so to speak. This is the person who may be able to access your bank accounts, who can talk to your bill to creditors, who can do those things on your behalf. Depending on the powers you give them in the power of attorney document, they can do a lot of things, a lot of things. One thing they cannot do is self-dealing. So if y'all are a power of attorney and the person you're power of attorney of is talking about, let's maybe do a ladybird deed or some kind of estate planning. If you will benefit from it, as power of attorney, you do not have the right to sign on that person's behalf. That is called self-dealing. That will get you in big trouble. However, if you are a power of attorney and you are doing something that is for the person you are power of attorney over, that is for their benefit, you may be reimbursed. So for instance, I have a client who calls, she's her brother's power of attorney. He is very sick and we need to evict the person who's squatting in his house. She uses her own money to pay the firm because she needs to help her brother, and there's some loopholes as power of attorney for her to go over and get his funds. She asks, can I be reimbursed for the expense I paid to get this person evicted? Because it's for the best interest of her brothers, because she's trying to protect the estate property, she's trying to actually get her brother home so that he can be at home in his final days. Because it's to his benefit, she absolutely can be reimbursed for those expenses. So just because you're power of attorney doesn't mean you're out of, you're gonna have to spend the money and you don't get reimbursed. But it does mean that you cannot do any self-dealing. So you can't just go take money from the account and spend it on yourself. You can't sign a deed on behalf of the person you're power of attorney for to deed yourself property. You cannot do those type of things. I hope y'all learned something today. Make sure you hit like or subscribe. And if you need an attorney in the state of Texas, make sure to visit us at cadillaclaw.net or give us a call at 972-845-1200. Thank you.